Welcome. The session on the Payment of Wages Act 1936. The Payment of Wages Act was enacted with a view to ensure that the wages are correctly disbursable to the workmen and timely payment and no deductions other than the authorized deduction permitted under law. Initially, the Act was applicable to only factories, but subsequently it has been extended to all activities of the business, including commercial shop and establishment and all other industries and business. Accordingly, state government has progressively extended the coverage of the application of the Act to different sectors. Now the Act is made coverable for all the establishments, namely the commercial or hospitality or ITS, BPOs, factories, plantations, mines, transport services, establishment engaged in constructions, maintenance, education institutions, a whole lot of things. Everybody is covered up. Now here the coverage of the provisions of the Act is for those people who are drawing a gross wage of 18,000 or less. So people who are getting more than 18,000 rupees per month, the Provisions of the Act is not applicable. Definition of employed person and employer is very easy. That employed person is an employed. He includes the legal representative of the deceased also. He is called employed person because to claim the wages payable to a deceased worker, he must have or she must have the status to claim. That's why he is also classified as employed person. Similarly, the employer also includes the legal representative of the deceased employer. The definition of wage factories, mines and plantation have got the same meaning as whatever defined in the respective legislations. As the wages is concerned, is a very, very wide coverage of definition. It covers all amount payable in cash for the work performed and done by him. It includes all allowances and incentives. Everything is included to the state in the definition of wages. But one thing, it does not include the bonus, value of any house accommodation, supply of water or light, and contribution to PF, travelling allowance, any sum paid to defray special expenses, and any gratuity. This is excluded from wages. Otherwise, it covers all payments gets covered under the definition of wages. The definition is inclusive one. Inclusive one. That's the important, including a reward and a settlement also. Remuneration is a return for the services rendered to an employee at any point of time during the employment here. Bonus is payable in return for the service rendered. Hence, it has been held that the bonus also is wages under the definition of wages under this Act. In the case of Sridharan Nair versus Sanku Sridharan and others, Kerala High Court held in 1969. The wages of the period of layoff falls within the definition of wages under the Act. Steel General Mills versus Additional Labor State, Punjab and Haryana High Court decision. Subsistence allowance paid given is by way of wages, but it's not by way of wages, but only with a view to see that the employee survives to face the inquiry. Hence, it is not accounted as service rendered, hence it will not amount to wages. So hence the subsistence allowance is not wages does not amount to wages as decided by Karnataka High Court in 1987. These are some few illustrations just to appreciate the definition of wages. Here, the compensation, like for instance the retirement compensation, he is held to be wages within the meaning of the Wages Act. Similarly, any compensation payable under section 25FF and 25FF, reduced section 25F would be wages within the meaning of the Wages Act. It means that the layoff compensation or even the retirement compensation is termed as wages for the purpose of all these things. Now, fixation of wage periods. Here, no other restriction. The wage period shall not exceed 1 month. It is stipulated. It is the responsibility of every employer to see that the payment of wages is made. He is responsible for payment of not only his labor, but the contract labor also, who falls under the provisions of the contract labor. Time of payment, if there are less than 1,000 employees, before 7th day. If it is more than 1,000 employees, before 10th day. Wages are paid in currency. Of course, now these things have been amended. Even the bank remittance is permissible, and that's also permitted now. In case of terminations, the wages had to be paid within the expiry of the second working day in case of termination cases. Now, deduction from wages. What are the permissible deduction from the wages? Fines is deductible. Absence from duty, damage or loss of goods, it can be deducted. House and accommodation provided. Amenities and service provided, not supply of tools and raw materials, that's excluded. Recovery of advances, deduction of recovery of loans from refund or housing loans, only to that extent it is limited. Income tax, professional tax, contribution to welfare fund, and orders to the court. Sometimes attachment of order of deduction also comes from the court from a debtor on the employee. Then by order of the court, we have to do the deductions. Then contribution to payments to cooperative societies and contribution to PF, ESI, LIC. These are the authorized deduction permissible under section 7. So any deduction other than this amounts to deductions not authorized by law, and this may lead to complications, etc. So any loss of wages resulting in imposition goods or sufficient cause, here what it says is that if you have to impose any deduction of wages arising out of damage or loss, then you have to adhere to the principle of natural justice. It means that the person should be issued a notice. It should be heard. You need to take an explanation from him, and you need to conduct an inquiry, hold an inquiry, and decide that he is literally found guilty of it. Then only you can impose and deduct the loss or damage caused. Otherwise, no, it cannot be unilateral decision on the employer's side. Unless the party is heard, unless the worker is heard properly and an opportunity is given, the order of deduction cannot be done. In case of the cooperative deduction, it is limited to 75% of the total wages you can deduct. In another case, it is limited to 50%. It means the take-home salary should be 50%. In case of this, in the cooperative, it can be 75 and 25%. Now here, many times we come across this kind of a case where the employees adopted the principle of go slow and also resorted to strike. In other words, they did not work on the principle of no more paid. The company said we will not pay. And the principle of go slow or participant go slow, and then here the question of deduction of wages for the go slow came in the picture. The court constituted under the payment is not competent to examine the go slow strike as legal or not, but the management is justified in deducting their pay for the period of strike. It has been held like that. One thing is legality, illegality, authority is not the question. It has to go to the proper authorities like tribunal or labor court or whoever it is. It can be done. Then the employee can deduct wages from section 7 from absent from duty. In such cases, the absence from duty must be taken of his own volition, because the employee absent from his place on his own. It is not deduction actually. It is that for the duration he doesn't earn the salary. So it is not, doesn't amount to deductions. So please understand the fine tuning of this argument. If a person is absent from place of work for 1 hour, it means that he has not earned the salary for 1 hour. So that's why he is not going to get the salary for it. It doesn't amount to deductions. That's how the Goetze court has said, and it is quite interesting. Then check-off facility given to a trade union on a voluntary basis. It can be withdrawn. It will hold good till the employee holds the authorization. The moment he withdraws the same, then union has no say on this, because the deduction of salary for union subscription is purely individual. If he withdraws the authorization, the union cannot say anything on this, they have to keep quiet. They cannot interfere. This is exactly the decision of Madras High Court in the case of State Bank Union versus State Bank of India in 1989. Then again, the direction for damages, the rules of natural justice dictates didn't demand that he must be given an opportunity. Then upheld once again in Nathalal versus MPRTC in Madhya Pradesh High Court. Now the principle I already explained to you just now to say that a show cause notice to be given, inquiry to be held, he should be heard before imposing any deduction for loss or damages. Now what is the procedure for levying in fines? See, fines shall be imposed on such acts and provisions which are listed and approved by the authority. Here, for acts of misconduct, you can levy fine, but only give a prepare such list and then get the approval of the authority. And the notice shall be displayed on the notice board. The acts for which the fines will be levied, it shall be displayed. And here also the opportunity must be given to the concerned workman to show cause and issue a hearing, and then only you can order the fine. Unilaterally you can't do it. So it means that before levying fine, you need to issue show cause notice, hear him, and then do it. And the fine amount shall not exceed 3% of wages payable to him. And no recovery fines in installment or after the expiry of 60 days of the order signing. So in the limitation, we cannot deduct that amount of fine in installments. It has to be only one go, not exceeding 3% of the total wages pay him on that particular month. That's all. You can't go on installment basis. And you can't levy the fine after 60 days for hearing. That's also very important. So every fine deemed to be imposed on day of the acts or omission itself. So these fines and realizations should not be utilized for any purpose as per the respective Labour Welfare Fund Acts. This amount has to be remitted to the Welfare Fund Board constituted under the concerned respective Welfare Fund regulations enacted by the respective states. Deduction from absent from duty. Now, if 10 or more employees acting in concern absent themselves without due notice and without reasonable cause, such deductions on such persons may include such amount not exceeding the wages for 8 days. Here, please understand, there should be 10 or more persons. They should act in concert and absent themselves or not doing any work without reasonable cause. Actually, it's amount to strike. The strike definition is the same thing. When we discuss on this issue, it should be a concerted action, unified action of stopping the work or remaining absent. Here also, if that happens, the employer can deduct the wages as a penalty for not exceeding 8 days. He can do it. But before imposing such duties, for such penalties, the employer need to issue individual notices to such workmen, call for explanation and take the explanation and then only pass orders. Otherwise, this will not be allowed to do it. So here the employee is supposed to carry this during working hours. In case he is refused to absent himself, again I said that absence is deductible by terms of employment and it can be deducted. The logic I will explain to you earlier. There are two prerequisites in invoking Section 92. Firstly, there will be strike without notice, that I told you already, and there must be a strike without reasonable cause, and strike should be found illegal, then ban in right reduction. However, the rules has to be followed. This has been reiterated by many cases like Madras High Court in India Cements, then Mysore Minerals Association in Karnataka High Court, and even Balaya case in AP High Court in Balaya's case in the AP High Court have been held the similar bails. Then deduction damage or loss, I told you already about this. Deduction shall not exceed the amount of damage or loss. Deduction shall not be made until he has been given opportunity of showing cause against deduction. All such deductions and all realizations shall be thereof shall be recorded and be kept. Then deduction for services rendered, no deduction shall not exceed the amount equal to the value of the house accommodation. That's absolute nature. Then deduction for recovery advances it provides. Then deduction of recovery of loans it also permits. Then deduction of payment for cooperative societies and insurance scheme this is also permitted under section 13. Now section 15 authorizes any person who prefers, for instance, if a person says he has not been paid the salary, he has not paid the wages of the day, or unauthorized deductions are made, or he paid less, any claims he can make the claim to the authority, and the employee, what is called to the state government may appoint presiding officer of a labor court to hear this case. Look at this. So they will very serious matter. It means that he can go out and approach the presiding officer of a labor court or a tribunal or any commissioner under Employee Compensation Act, and he is the authority under the act. Then an employed person, any legal practitioner or any official registered trade union, any representative of a deceased person, anybody can expose the cause. Such application will be presented within 12 months from the date of deductions, and authorities shall hear the parties in line with principles of natural justice and empowered order compensation not exceeding 10 times the amount deducted, and the employer has to pay this. The inquiry under this section is deemed to be a judicial one, which is the meaning of the provisions of the Indian Penal Code. So here is very important to notice. It means that we should never violate the provisions of the law at any point of time, because there will be always the risk of this. Any person can go and then file a claim before these people, before these authorities, and the authorities also very quite senior, equal to that of a civil judge or a magistrate, and the inquiries will be absolutely judicial one. So one has to be very careful and cautious on this. Can a group of persons make a single application for claiming deductions? This can be done if they are all working in the same establishment and deduction have been made in a similar way. They can always prefer a common application and then it can be presented. Now, can an employee file a suit against employer seeking injunction against any making deduction from his wages? Can he do that? No, because civil courts are totally debarred from interference of this Payment of Wages Act. The authority alone he can go, no other court. So civil court has no jurisdiction. He cannot file any case for bringing any injunction for this purpose. An agreement between an employer and employee authorizing deduction of union is quite possible, is valid, because it is being a beneficial advantage to the employees and is not null and void under section 23 of the Act, is permitted. Then what is the responsibility of the employer in respect of unpaid, remaining unpaid on account of death of an employee? An employer shall stand discharge of liability in such way that if he pays them to the nominee of the deceased person, or in case he is not able to do, if this is a prescribed authority, he can come out of this. It means that if he is not able to find out the nominee or whoever it is, he can deposit the money with the authority and his responsibility will not be there. So this is all about the Payment of Wages Act. So thank you.